Imagine being sentenced to death for a crime you didn't commit. Imagine spending 30, 40, or even 50 years fighting to prove your innocence while the real perpetrator walks free. This isn't fiction. It's the devastating reality these 5 individuals faced in the American justice system. Welcome back to the Verdict Room, where we expose the cracks in our legal system and break down cases that changed everything. I'm your host, and today we're examining 5 truly haunting stories of wrongful conviction, cases so shocking that they forced lawmakers to reconsider how justice is actually served. By the end of this video, you'll understand why innocent people can spend decades locked away and what it took to finally set them free. Let's start with a case that will make your blood run cold. In 1985, Anthony Ray Hinton was arrested in Birmingham, Alabama, for 2 murders he absolutely did not commit. The evidence against him? A ballistics test performed on guns found at his home that allegedly matched the murder weapon. But here's where it gets infuriating. Hinton couldn't afford a proper defense, and his court-appointed lawyer had literally fallen asleep during the trial. We're not exaggerating. This actually happened. Hinton was sentenced to death, and he spent 30 years on Alabama's death row. 3 decades knowing he was innocent, watching appeals fail, and preparing himself to be executed. Then in 2015, new DNA evidence and a re-examination of those ballistics tests proved the guns didn't match. The real evidence had been suppressed all along. At age 60, Anthony Ray Hinton was finally released, completely exonerated. He had lost 30 years of his life to a system that failed him catastrophically. Now, let's talk about a case that represents one of the most egregious failures of justice in modern American history. In 1983, Henry Lee McCollum and Leon Brown, 2 black teenagers, were convicted of a rape and murder they didn't commit in Pembroke, North Carolina. The conviction was based almost entirely on false confessions extracted during questioning. No physical evidence tied them to the crime, no witnesses could reliably identify them, yet they were both sentenced to death. McCollum and Brown spent decades on death row, their youth stolen by wrongful conviction. In 2014, more than 30 years later, DNA evidence definitively proved their innocence. The actual perpetrator was identified through that DNA evidence, and he eventually confessed. McCollum and Brown were exonerated, but you can never get back 30 years. They became the longest-serving death row exonerees in American history. This case exposed how fatal false confessions can be and how the system often fails to properly investigate when confession alone drives a case. Let's move to another heartbreaking story. Dwayne Jackson was convicted in 1984 of a rape in Washington, D.C., and he received a sentence of 60 years. Here's the critical detail. Jackson was identified through a misidentification by the victim. Eyewitness identification is notoriously unreliable, especially in traumatic situations, but it was the anchor of his entire conviction. Jackson maintained his innocence for years while serving his sentence, and he was right to do so. In 2012, after nearly 30 years in prison, DNA evidence proved Jackson's complete innocence. He was released, exonerated, and the case was reopened. What happened? The real perpetrator was never even investigated initially because the system accepted the victim's identification without proper scrutiny. Jackson's case illustrates a fundamental problem in criminal law. Eyewitness identification, despite being unreliable, remains one of the most persuasive forms of evidence to jurors. Innocent people go to prison for this reason far too often. Now, here's a case that showcases corruption at the highest levels. Walter McMillian was convicted of murder in Monroeville, Alabama, in 1988, and he was sentenced to death. McMillian's conviction was built on perjured testimony from a career criminal who had been coerced by police into lying. Even worse, critical evidence that could have proven McMillian's innocence was suppressed by prosecutors and investigators. This wasn't just a mistake, it was intentional misconduct. McMillian spent 6 years on death row before his case was finally reopened by the Equal Justice Initiative. Investigators uncovered the prosecutorial misconduct, the false testimony, and the hidden evidence. McMillian was exonerated and released in 1993. His case became a catalyst for reform because it showed that our justice system's protection against wrongful conviction was broken at the institutional level. Innocent people weren't just being convicted by accident. They were sometimes being deliberately framed by those sworn to uphold justice. Our final case brings us to Clarence Elkins, a man who lost 11 years of his life to a crime he didn't commit. In 1998, Elkins was convicted of rape and murder in Akron, Ohio, based on evidence that investigators had misinterpreted. The crime scene physical evidence was there, but it didn't match Elkins. It matched someone else. Yet investigators convinced themselves Elkins was guilty, and the prosecution moved forward despite this contradictory evidence. Elkins was sentenced to 2 consecutive life sentences. In 2003, DNA testing definitively proved Elkins's innocence and identified the actual perpetrator. Elkins was exonerated and released after 11 years in prison. His case represents a common problem: confirmation bias in law enforcement. Once investigators decided Elkins was guilty, they didn't seriously consider alternative explanations for evidence that didn't fit their narrative. Even DNA, which should have cleared him, was overlooked or misinterpreted to fit the predetermined conclusion. Now that we've examined these 5 cases, we need to talk about what they have in common. Almost every single one of these innocent people fell victim to multiple systemic failures. First, inadequate legal representation. Many couldn't afford proper defense counsel, and public defenders were overwhelmed or, in Hinton's case, literally asleep. Second, false confessions and unreliable eyewitness identification were accepted as gospel truth without proper scrutiny. Third, DNA evidence existed, but was either suppressed, ignored, or not properly tested. Fourth, there was prosecutorial misconduct and police misconduct. Evidence was hidden, witnesses were coerced, and investigations were biased. Fifth, appeals courts and judges were reluctant to overturn convictions, even when new evidence emerged, deferring too heavily to juries and trial verdicts. The legal system is designed with safeguards, but those safeguards only work if everyone involved, police, prosecutors, judges, defense attorneys, is acting with integrity and diligence. When those systems break down, innocent people pay with their freedom. These cases also share another sobering reality. They almost all involve defendants who were poor and often belonged to racial minorities. The American justice system, for all its promises of equal protection, has historically been unequal. Those with resources can afford expert witnesses, thorough investigations, and appellate representation. Those without resources are left vulnerable to the failures we've seen in these 5 cases. Here's what we need to understand moving forward. Wrongful convictions aren't anomalies in our justice system. They're symptoms of deeper structural problems. The Innocence Project, founded in 1992, has exonerated over 375 people in the United States since its inception, primarily through DNA evidence. 375 people. And these are just the cases where DNA evidence was available and could be tested. The real number of innocent people in prison is likely much, much higher. The good news? Some of these cases have led to real reform. States have implemented eyewitness identification protocols based on psychological research. Some jurisdictions now require the recording of confessions. DNA databases have expanded, and organizations like the Innocence Project have brought resources to cases that the traditional legal system ignored. But we still have a long way to go. More resources need to be dedicated to reviewing old cases. More training is needed for police on the dangers of confirmation bias. Prosecutors need better incentives to pursue justice rather than convictions. So what's the takeaway from Anthony Ray Hinton, Henry Lee McCollum, Leon Brown, Dwayne Jackson, Walter McMillian, and Clarence Elkins? It's that our justice system is only as fair as the people running it, and when those people fail, whether through negligence, bias, or outright corruption, innocent people suffer incalculable harm. These 6 individuals were eventually exonerated, but 30, 40, 50 years of their lives were gone. Their families were torn apart, their potential was lost. The question we must ask ourselves is this: how many innocent people are still in prison right now, maintaining their innocence, but without the resources or luck to find the evidence that will prove it? How many are going to die in prison for crimes they didn't commit? That's the real verdict this room demands we consider. If you found this case breakdown as disturbing and thought-provoking as we did, please subscribe to The Verdict Room. We dive deep into cases like these every week, exposing the truth and analyzing the law. Leave a comment below telling us which case shocked you the most and what you think needs to change in our justice system. And if you know someone who should hear about these stories, share this video. Thanks for watching, and we'll see you in the next verdict room.